Hello again, my name is Alexa. I'm the moderator for the evening. I'm the Special Projects Coordinator at Special Needs Cobb here in Marietta, Georgia. Special Needs Cobb is Cobb County's original special needs organization, having been in operation for 66 years. We own and maintain 23 group homes for special needs adults in the area, as well as providing facility-based respite services and other resources for special needs families, such as this workshop. Our presenter tonight is attorney Kim Martin. If you went to our last workshop, you already know her, but for those of you who don't or need a refresher, Kim is a trust and estate attorney and focuses her work on estate planning for special needs families. She's a partner at Harrison and Held LLP, a board member here at Special Needs Cobb, and she is mom to 2 kids, one of whom is autistic. We're so happy to have her here tonight to talk to us about special needs planning. There's really nobody else better than her to talk to you all about this. So I'm going to go ahead and hand it over to Kim, and I'll see you all at the Q&A.
Okay, can you hear me, Alexa?
Yep.
All right. Well, thank you so much for letting me come and chat to everybody, albeit virtually. I think, yeah, here's a little bio, but I think Alexa has already told you all kinds of stuff about me. I think probably my most important credential is that I am the mother of a child with autism. That caused me to reinvent my practice years ago. I used to be a tax planner, and I have now become a 100% special needs planner and guardianship attorney. And I also work with families that are divorcing and who have a special needs child. But today's talk is about my favorite thing to do, which is special needs planning. Before I can get into all the fun stuff, I have to give you my boring legal disclosure. But the purpose of this workshop is purely to educate all of you. So nothing that I say tonight should be construed as legal advice. This is just purely educational information. Any opinions that I express tonight are purely my own. They are not reflective of any opinions of any local, state office. It's just me giving you my thoughts about anything that I express as an opinion. And finally, this meeting is not a substitute for a meeting with an attorney who practices special needs work and who understands your situation and can give you specific advice based on your facts. So now that that's out of the way, before we really can talk about special needs planning, it's, I think, worthwhile to take a minute and think about whether a special needs trust is really appropriate as part of your estate plan. And in order to determine that, the first question that you need to ask yourself is, does your child meet the statutory definition of disabled as far as public benefits are concerned? So if you have a child who's under age 18, then the definition of disabled is somewhat general. They need to have a medically determinable physical or mental impairment. So they need to be diagnosed with something that results in marked and severe functional limitations. So that's not a super precise description, but if your child fits that description before the age of 18, they are considered disabled for the purpose of qualifying for benefits. And once they reach the age of 18, the definition of disabled changes and it gets a bit more specific. So if you're over 18, then you are considered to meet that definition of disabled if you have one of those medically determinable physical or mental impairments that can be expected to result in death or will be expected to last for at least 12 months and prevents you from engaging in what's called substantial gainful activity. And you'll often see that abbreviated to SGA. So substantial gainful activity is essentially paid work. And it's a dollar test, and that dollar test changes every year. It gets adjusted for inflation. So for 2022, the test of whether you can engage in substantial gainful activity is whether you're capable of holding a job that routinely earns you either $1,350 a month or more, or if you're legally blind, that number becomes $2,260 a month. So SGA means you can't engage in any activity that would result in you earning more than those statutory numbers. So you have to have an impairment that's so severe that you can't do any type of work. That doesn't mean you used to have a job that paid you $50,000 a year and you now have a condition that prevents you from making that much money or from doing that type of work. You have to be unable to do any type of work that would pay you either $1,350 a month or $2,260 a month. So assuming that you meet that definition above the age of 18 of being unable to engage in substantial gainful activity because of some type of diagnosis that you have, that means that you do meet the statutory definition of disabled. And we move on to question number 2, which is, does your child either receive or expect to receive means tested benefits? The means test is another dollar test. It's in order to pass the means test, your child has to have less than $2,000 in non-exempt resources. So there are lots of means tested benefits. The 2 big ones that people care about the most and that their children tend to qualify for at age 18 are SSI and Medicaid. But in Georgia, we also have SNAP benefits, which is what we used to call food stamps. There's Section 8 housing eligibility. In Georgia, as a practical matter, that's not particularly useful because there's a real shortage in the supply of Section 8 housing. So even if your child qualifies for it, it's unlikely that there would be any Section 8 housing available for them to live in, or at least not any that you would want them to live in. And then there is also a state trust fund for people who've had either a traumatic brain injury or a spinal cord injury. And that is also a means tested benefit. But the 2 big ones are SSI and Medicaid. And those are the 2 that we're going to talk about a little bit before we talk about planning for those benefits. So the first thing that we'll talk about is SSI. And as noted, SSI is a means tested benefit. What that means is that if your child turns 18 and they have more than $2,000 in non-exempt resources, then they pass the means test and they may qualify for SSI. Until your child is 18 years old, all the resources that are available to take care of that child count as resources that are non-exempt for that child's care. And that's why most of our kids don't qualify for SSI until the age of 18. Because until they're 18, they're minors and we have to take care of them. We're required to give them food and shelter by law. Once your child turns 18, your child will become a household of 1 for Social Security purposes. Even if they live with you, even if you let them live in your house for free and feed them and completely support them, even if they're still in school, as long as they're not married or emancipated in some other fashion, your child is a household of 1 at age 18, which means Social Security stops paying attention to what you have. They don't care about your resources anymore. They only care about what resources your child has. So if your child personally has less than $2,000 in non-exempt resources, then they pass the means test. There's also an income test to qualify for SSI, and SSI pays attention to any type of income that your child has. So if your child has earnings from a job, that's obviously income, but even unearned income counts and can either reduce or eliminate SSI. So we see this come up a lot in divorce situations where child support is being paid for the child. If your child reaches age 18 and you happen to be divorced and one of the parents is paying child support for that child, Social Security considers the child support to be the child's income, even if it's not getting paid directly to the child, because usually it isn't. So they will disregard the first $20 of that child support every month, and all the rest of it will offset SSI dollar for dollar. Unless you do a particular type of planning where the child support gets paid into a first party special needs trust, which is one of the trusts that we're going to talk about later. So that's fixable. But if you just have child support being paid for the benefit of a child who would otherwise qualify for benefits, if it's getting paid directly to the other parent, then that dollar for dollar offset will apply after the first $20. So we'll talk about that later because that can be fixed. So for the calendar year 2022, the greatest amount that you can expect your child to get in SSI is $841 a month. That's a weird number, and that's because SSI adjusts for inflation every year. So it gets boosted, $3, $11, some random strange number. A few years ago, we supposedly had no inflation and it didn't budge at all that year. So, but this year it's $841 a month unless it gets reduced for some reason. And as we've already talked about a little, you can have SSI reduced or even eliminated if you have too much income or too many resources. So even if your child qualifies for SSI, and then later they come into some money that's more than $2,000, they can lose it. And all of that is fixable, but you just need to be aware that once your child begins to apply for SSI, you want to keep them below $2,000 in non-exempt resources. And in Georgia and in many states, SSI is linked to Medicaid. And what that means is that if you qualify for SSI, you don't even really have to apply for Medicaid. You can just go get it. So if your child applies for SSI and they get SSI, then you would take their SSI acceptance notice and you could go to the Department of Community Health, which administers Medicaid, and you could say, look, my child has SSI, and they'll just give him a Medicaid card. There's no applying for it separately. So that brings us to our next big means tested benefit, which is Medicaid. Family resources, just like with SSI, do count for the purposes of the means test for Medicaid until your child reaches age 18. But there's a special type of waiver that applies to Medicaid that I'm sure many of you have heard of, and probably a lot of you actually have. It's called the Qbt Beckett Deeming Waiver. And the reason it's called a deeming waiver is because if you can demonstrate that your child is sufficiently disabled, sufficiently incapacitated to meet that special qualification for the deeming waiver, then Medicaid will overlook the fact that your family has too many resources, and they will only pay attention to the resources that your child has, even if your child is under the age of 18. So if you have a minor child who you believe should qualify for Medicaid, except for the fact that the family has too many resources, you should be able to apply for the Qbt Beckett Deeming Waiver and potentially get Medicaid coverage for your child even before the age of 18. Medicaid is I almost feel like it's a little bit meaningless to say Medicaid because there are over 30 different types of Medicaid. There are lots and lots of different kinds. So the straight up Medicaid that is medical insurance is the type of Medicaid that your child would get under Qbt Beckett and that your child will get in connection with SSI, probably when they turn 18. But there are other types of Medicaid benefits that might be helpful later in your child's life. One of them is called Qbt Medicaid. That is a type of Medicaid that will pay the monthly premium to get supplemental Medicare. So many years probably down the road after your child turns 18 and hopefully qualifies for SSI, when one of the child's parents either dies or becomes disabled and starts to draw Social Security, or retires and starts to draw Social Security, then your child at that point will roll over from SSI to SSDI. And 2 years after they're on SSDI, they will qualify for Medicare as opposed to Medicaid. And Medicare is that medical coverage that we all get when we turn 65. So they'll get that same coverage regardless of what age they are, 2 years after they begin SSDI based on a parent's work record. So if you're familiar with Medicare, you already know that there's a sort of a central piece of Medicare that all of us get for free. But if we want additional components of Medicare, for example, the prescription drug benefit, we can get that additional coverage by paying a monthly premium to get it. So if your child still passes the means test when all of this stuff happens, they can qualify for QBT Medicaid, and QBT Medicaid will pay their Medicare premiums. The now comp waivers are the big kind of shiny brass ring of Medicaid benefits. The now waiver is a little bit less money than the comp waiver, but both of those waivers will pay for various types of support that will allow your child to live as independently and happily and safely as possible. Georgia is one of the states that has opted not to fully fund its Medicaid waiver. So some states take the federal money from Medicaid, and then they contribute additional state funds to make sure that everybody in their state who qualifies for a Medicaid waiver gets it. In Georgia, we don't do that. Most years, Georgia creates 100 new Medicaid waivers. This year, I think they created 200. There are over 7,000 people on the waiting list for the now comp waiver. So this is something that is given to people based on level of need, which means as long as you've got a fairly young child, even a young adult child, and you are still fairly young parents, and you have income and you're healthy and you've got the resources to take care of your child, it's likely that your child is going to hang out on the waiting list with 7,000 other people until something happens that causes their level of need to go up. So a lot of times that will happen if a parent dies, or if a parent has gotten elderly or has become diagnosed with some type of condition that makes it impossible for them to take care of their child. That's when we typically see kids getting now or comp waivers in Georgia. I know a mom who moved from California to Georgia, and in California, apparently you just sign up for the comp waiver and they give it to you. You just go and sign up and there it is. And she came to Georgia and was absolutely shocked that her 35-year-old son had to get on a waiting list for a waiver. So it is what it is. But meanwhile, while we're all sitting there on the waiting list, there's sort of a consolation prize. It's called family support. It's not Medicaid per se, but it's a program that is funded with Medicaid dollars. And it's available to families in many counties in Georgia. I don't believe it's available in every single county, but family support is a budget that you get. It's $3,000 a year. And if your child has behavior issues or other severe need that escalate the level of support, then it can be more than that. My son is on family support for $3,000 a year, and it pays for summer camp or swimming lessons. In his case, it can pay for art class or dance classes, or in some cases, it'll pay for transportation to an activity. It is intended to pay for any type of activity that will help the recipient to integrate into the world and live as independently as possible. It's there to help your child sort of live his best life. So if you're on the waiting list for a now comp waiver, you should look into whether your child qualifies to get family support, which they would stay on until they get one of the waivers. And then another type of Medicaid that it's good to know about, this is very far down the path for most of us, but there is a type of Medicaid that's called nursing home Medicaid. And just like it sounds, it will pay for your stay in a nursing home, but nursing home Medicaid is means tested. So if you have too many resources, then you don't qualify for nursing home Medicaid. So for all of these reasons, even after we go from SSI to SSDI, which is not means tested, and from Medicaid to Medicare, we still care about the means test. Another noteworthy thing about Medicaid is that it's subject to a state recovery, meaning at your child's death, Medicaid is going to pull out this long list of every single benefit they've ever paid for during your child's lifetime. And they're going to ask your child's estate to reimburse them to the extent that that's possible. Now, assuming that your child has met the means test for his whole life, his estate is not going to have a whole lot in it. But Medicaid considers any money that's in an ABLE account to be part of your child's estate, and any money in a first-party special needs trust is also subject to Medicaid payback. And we'll talk about that stuff more later. So what does this all have to do with special needs planning? We haven't talked about special needs planning at all so far because we've been talking about benefits, but we needed to know about benefits in this case because that's really what special needs planning is for. Special needs planning is a combination of estate planning and benefits planning. Special needs planning is how you keep your child qualified for all these nice means-tested benefits and also arrange to leave assets to take care of them at the same time. So knowing how these benefits work is really at the heart of special needs planning. So any special needs planning initial meeting should involve a pretty robust discussion of what benefits your child is on, what benefits they could be on, what benefits you'd like them to be on in the future, because that's really what special needs planning is. So the rest of this workshop is going to be about special needs trusts. There are two commonly used types of trusts that we use in special needs planning, and the main difference between the two is the source of the funds. So these types of special needs trusts are known as either first-party special needs trusts or third-party special needs trusts. These are two different trusts. They have two different jobs. You can't use one trust for all the jobs. And you'll see why when we talk about the differences. So the first-party special needs trust, sometimes you'll hear that referred to as a self-settled trust, or sometimes you'll hear it referred to as a D4A trust. It's called a first-party special needs trust because it's designed to hold first-party funds. And that means money that belongs to your child or that your child has some sort of an interest in. So some examples of first-party funds would be intestate inheritance. If somebody dies without a will and your child is in line as one of their intestate heirs, they're going to get assets paid directly to them. And that is just hopelessly first-party money. There's nothing we can do about it. If your child is the beneficiary of a trust, maybe something set up by a well-meaning grandparent that is not a special needs trust, all the assets in that trust are considered to be an available resource to your child because it's not in the proper type of trust. So the way that you would fix that problem is there are various ways to fix the problem, but one way or another, you'd have to get the funds out of that non-special needs trust, and you could put the funds into a first-party special needs trust, and they would immediately become an exempt resource, subject to Medicaid payback. So that's not the ideal way to provide for your child, but it's better than disqualifying them from means-tested benefits. Tort settlements. So if your child is in a car accident, let's say, and they get injured and they get a damages award, that money is first party money. And if you have a good personal injury attorney who knows what he's doing, he will ask the court to order that those damages get paid into a first party special needs trust so that we don't disqualify your child from SSI and Medicaid. Any kind of surprise income that falls out of the sky. There was this little flurry of panic when COVID set in, and a lot of my clients had their kids getting those PPP checks or unemployment insurance that was paying much more than the child was earning. And they were calling me just totally freaking out because they weren't sure what to do about it. And in the case of the PPP checks, there was a special dispensation by Social Security because they realized this money was just sort of involuntarily getting paid to people that needed to pass a $2,000 means test. So Social Security said that the PPP checks were exempt for, I believe it was 6 months after they got paid. So it gave people time to figure out what to do with them. But if any money just randomly falls out of the sky and lands in your child's lap, if grandma and grandpa say, we're going to give all the grandkids each a check for $10,000 this year, or something like that, that would be money that you could put into a first party special needs trust to cause it to be exempt. We already talked about child support a little bit. Child support that's getting paid for the benefit of a child who is a special needs child after the age of 18, except for the $20 disregard, is going to offset SSI dollar for dollar. The way that you fix that so that the child can get child support and still qualify for SSI is that you have to have your settlement agreement provide that child support payments after the age of 18 will be paid to a first party special needs trust. So it's actually not that hard and it's totally fixable, but a lot of family lawyers are not aware of this issue. So sometimes the special needs parent has to educate their family lawyer. Another great use for a first party special needs trust is if you're in the military and you are entitled to a pension, the military pensions not only provide that you can name your surviving spouse to get survivor benefits on your pension, you can also name your disabled child as the recipient of a remainder interest in your pension. So 5 or 6 years ago, the rule was you have to name the child, which was a horrible mess because that disqualified them very often from any means tested benefits. And they had an income that counted against them as well. So then eventually the military changed its rule and said, if you have a special needs child and you want to name them as the remainder beneficiary of a military pension, you can name a first party special needs trust to receive those pension benefits. So it won't count against the child. It won't reduce their ability to qualify for any benefits, but it's a way that you can let your pension provide for your child in addition to your own estate planning and in addition to qualifying them for public benefits. So again, just a reminder, anything that you put into a first party special needs trust is going to be subject to Medicaid payback at your child's death. So if you do have a first party special needs trust, or if you get one in the future because you need to stick some money away and cause it to be exempt, it's not necessarily a big deal. We would certainly rather have the child qualify for benefits for their whole lifetime and then potentially have to pay some of those benefits back than disqualify them altogether. But to the extent that there is money in a first party trust, it has to be used for Medicaid payback at the child's death. A third party special needs trust is called that, again, pretty obviously, because it holds third party money, which means money that belongs to anybody except your child. So a third party trust can hold your money. It can hold grandma and grandpa's money. It can hold anybody's money in the world except your child's money. Sometimes you'll hear these third party trusts referred to as supplemental needs trusts. A special needs trust and a supplemental needs trust are basically the same thing, but Social Security uses the term supplemental needs trust when they're talking about a third party special needs trust. So third party funds, as I said, are funds that belong to anyone except your child. So if grandma and grandpa want to make that $10,000 gift and they want to treat all their grandchildren the same, if you have a third party special needs trust, you can just tell them, no problem. You can still give my child the $10,000, but don't give it to the child. Make the check out to the trustee of the blah, blah, blah special needs trust. And then the money can go in the third party trust. And because it never belonged to your child, that's perfectly fine. The third party trust can be the beneficiary of an IRA. It can be the beneficiary of a life insurance policy. It can hold anything that you want to put into it, except money that belongs to your child. So the reason that we care about this distinction about which trust we can use for what type of asset is because the third party trust, because those assets never belong to your child, doesn't have a Medicaid payback at death. So some of my clients, if they've got multiple kids and, one of their kids is going to need financial support for the remainder of his life, the others may be doing great. The parents want to get him through college. They want to get him settled in a career, maybe help him out with a car or a house. But as those kids get older, their needs are going to be met by, their own employment. In that situation, sometimes when we do planning, my families will decide that they're going to kind of super fund the third party trust. So if we have 3 kids, instead of dividing the estate by 3, we might say these 2 kids each get 25% of the estate, and my special needs child gets 50% because his needs are greater or his needs are going to go on longer. And that's completely a judgment call. It's a decision to make with your planner and maybe with a financial planner. But that's what some people decide to do. And one reason that a lot of people feel okay about doing that is because they know that when they create the third party special needs trust, they can name their other kids as the remainder beneficiaries. So at the end of the special needs child's life, any assets that are still left in that third party trust can go to the other kids. So if we need it for the special needs child, we have it. If we don't need it, it will ultimately go to the other kids or to the grandkids, to the children of the other kids, just depending on who's around when that trust terminates. So there is a type of trust called a pooled trust, and it can be either a first party trust or a third party trust. The way a pooled trust works, it's kind of like a mutual fund. Pooled trusts are generally designed to hold amounts of money small enough so that it would be really hard to find a professional trustee who will take it. If you use a corporate trustee like a bank or a private trust administrator like Cumberland Trust Company or Southeastern Trust Company, some organization that just administers trust for a living. If you present them with a private trust, they're going to charge a percentage of what's in the trust, and that'll be their fee for making investment decisions and doing administrative work with regard to the trust, taking care of the taxes and the accounting to Medicaid and all of that stuff. If there's a small enough amount of money in the trust so that the fee to manage it privately would just be prohibitively high, a pooled trust is the way that some people decide to handle that situation. So the way they work is these people that have relatively small amounts of money, and this could be, $50,000, $100,000, or less than that, they will join the pool. So there is a take it or leave it trust agreement. You don't go to a lawyer and have them write up a trust for you and then dub it a pooled trust. You find a pooled trust that's out there in the world being administered, already, and you take this trust agreement that they'll give you and you sign on. There's one trustee that takes all the trust assets from everybody who's joined the pool, and they treat that whole pot of assets as one investable pot of money. So the trustee will manage all of those assets as one unit, and they'll parcel out gains or losses and tax liability with ratios that match your percentage of investment in the pool. So just in the same way that if you want to diversify a portfolio and you don't have enough money to buy enough shares of all the different types of stock out there, you can take a smaller amount of money and you can buy shares in a mutual fund, and the mutual fund manager would take your money and take everybody else's money and buy a diverse portfolio, and then you would share in the gains and losses. That's exactly what a pooled trust does. And you get economies of scale by joining a pooled trust. So the fees tend to be lower. Typically, there's a fee to join the trust. And then every year, there is a fee to participate in the trust, but it's a smaller percentage of what's in there than you would pay for a private trust to be administered by a corporate trustee, like a bank. So you don't need a lawyer to get into a pooled trust. You just identify a pooled trust that you feel good about, and they will give you their trust agreement, and you sign it and you join. So I think I mentioned this already. The pooled trust could be a first party pooled trust, meaning that there's a Medicaid payback at death. Although sometimes with the pooled trusts that you have a choice of choosing either I choose to reimburse Medicaid with this money, or I choose to let the pooled trust have whatever money is left at my child's death. But either way, you can't direct where the money goes. You can't direct it to other family members. You can also join a third-party pooled trust. And in that case, there is no Medicaid payback because it's a third-party trust. So just letting you know that they're out there. So we'll talk more now about first-party trusts and what their characteristics are and how they work. And then we'll talk more about third-party trusts. The first-party trust you've probably already gathered is a damage control trust. We don't want to go out of our way to put money into a first-party trust because of the Medicaid payback, but it's a great little trust to use if you get presented with a problem or even an opportunity in some cases. So if you're in the military, as I mentioned before, and you have pension money that you'd like to have take care of your child someday, the first party trust is the perfect way to do it. If you've got child support being paid for your child and it'll continue to be paid beyond the age of 18, it's a way to keep that child support being paid and also allow your child to qualify for benefits. But the first party trust is also there if somebody has just royally messed up. If we have one of those well-intentioned grandparents who bought your child a lot of bonds when they were born or created a trust for them that's not a special needs trust, the way that we can fix that problem and qualify them for benefits is to create a first party trust and roll the assets over. It's one of the names for a first party trust I mentioned is a D4A trust. It's called a D4A trust sometimes because this trust is a creature of statute. There is a statute that tells us here is the way that you have to structure this trust. So we don't have a lot of choices about the provisions that we would include in a first party special needs trust. Only certain people under the statute are allowed to create a first party trust. So a first party special needs trust can be created by the beneficiary if he has capacity, meaning that he's over age 18 and he has the intellectual capacity to understand what he's doing in creating the trust. A parent can create a first party trust for their child. A grandparent can create a first party trust for a grandchild. The only other way that we can create a first party trust is to have a court create it by court order. And typically that happens either in a divorce settlement agreement or in a personal injury situation where the child has been injured in an accident and we have damages, and we're asking the court to order those damages to be paid into a first party special needs trust. So the first party trust is subject to something called the sole benefit rule. And the sole benefit rule is that that trust has to be administered and the funds have to be distributed for the sole benefit of the beneficiary, meaning we can't make distributions from that trust that benefit anybody else. Everything that gets spent from that trust has got to benefit the one trust beneficiary, the primary beneficiary, nobody else. A first party trust has to be irrevocable on the day you sign it. Meaning, if you create an irrevocable trust, that means you're very limited in the ways that you're able to modify the trust. And obviously, you can't revoke the trust. You can't just decide, I don't want this trust to exist anymore and make it go away and take all the money back. So anything that goes into an irrevocable trust cannot just be arbitrarily taken out. It has to come out in the form of some type of distribution. A first party trust is also required to be an inter vivos trust. Inter vivos means during life, meaning that it cannot be created under somebody's will. You have to create it during your lifetime. You're not allowed under the statute to create a first party special needs trust for somebody who is over age 65. And if you create a first party trust before the beneficiary is age 65, you can't fund it with any additional funds after they reach age 65. There is a way to use first party trusts for Medicaid planning for an older family member if you have the right facts. So not everybody would be appropriate for this type of planning. But if you have an older person, it's typically, let's say you have a grandparent and they don't have a lot of resources, but they have too many resources to qualify for nursing home Medicaid. So the family is looking at a situation where we can either spend all these assets down until the point where the grandparent is truly impoverished and let them qualify then for nursing home Medicaid, or if we have somebody else in the family that a special needs trust would be appropriate for. Let's say we have a grandchild who has special needs. We can take grandma's $80,000, $90,000, whatever it is that we would otherwise have to spend down before grandma gets nursing home Medicaid. And we can create a first party special needs trust for the grandchild. Grandma can fund that trust, immediately qualify for nursing home Medicaid. So it's not everybody's dream scenario. She is essentially disinheriting everybody else in the family. But if the alternative is grandma has to spend every dollar of this before she qualifies to get nursing home Medicaid, then there's not going to be anything for anyone to inherit anyway. So in certain situations, if we have an older family member whose assets are too high to qualify them for nursing home Medicaid, but not high enough so that they're really going to be able to pay for their own care for the rest of their life, sometimes we can use a first party trust for Medicaid planning for two people at the same time, in a sense. And then we get to sort of kick that can down the road. So we have put that money into a first party trust and there's a Medicaid payback at death, but we've put the money into a first party trust for a much younger person who presumably has a longer life expectancy. And we have the child's lifetime to use up that money. And if there's nothing in the trust at the child's death, then there is no Medicaid payback. So third-party trusts are way more flexible than first-party trusts because they are not created by statute. So the third-party trust is a classic estate planning trust. It's not created, as I said, by statute. It was sort of created by the seat of the pants by many, many people who were doing special needs planning a few generations ago when there was no guidance whatsoever as to how to write a special needs trust that was going to be approved by Medicaid. So it's probably the generation before me of special needs planners. There was no guidance, and people would just kind of put provisions together based on their best guess as to what was going to work, and then get together and go, well, I did this and it got approved. So because there's no really strict guidance as to how to create a third-party special needs trust, we do have a little bit of formal guidance now since the late 1990s, but that's relatively new. We have a lot more flexibility as to how we can create these trusts. So unlike the first party trust that has this strictly limited group of people who are allowed to be the grantor of the trust, anybody can create a third party special needs trust except the beneficiary. There is no sole benefit rule. So in theory, if you had two special needs kids, let's say, and you wanted them both to benefit from the same third party special needs trust, you could do that. There might be other practical reasons that you don't want to do that, but you could, because there is no sole benefit rule. We can have more than one beneficiary of a third-party special needs trust. You could even have, if you have a special needs child and a neurotypical child, and you want them both to be beneficiaries of the same trust, you could have a trust that has a third-party component, a third-party special needs trust component in it those would be the terms that we would use to administer the trust for a special needs child. And then the neurotypical child might have a different distribution standard. It's, as a practical matter, all of that gets a little bit messy, and it's probably more sensible to just create a separate third-party special needs trust for your special needs child. But in theory, you're allowed to have another beneficiary as well. So the first party trust has to be irrevocable. The third party trust, you have a choice. You can make it revocable or irrevocable. If you make it revocable, what that means is, in addition to being able to just revoke it and take all the money back and call it a day, you also have the ability to modify the trust in any way you want to during your lifetime as the grantor. So what I see most often is people will create a third-party special needs trust, and then years will go by and they'll look over their list of trustees and they'll say, you know, this person has dementia. I don't think we really want them to be in our list of successor trustees anymore. Or they will create the trust when all of their kids are young, and then 10 or 15 years will go by and they'll realize, you know, wow, we've got a daughter who's a CPA and she'd be a fantastic successor trustee. Let's add her to our list. So people will change their trust provisions to mess around with their list of successor trustees. It's also helpful to have the ability to modify your trust with an amendment if changes happen in the law. So sometime around 2017, ABLE accounts had really become a thing, and previous third-party special needs trusts just didn't address them at all because they're not that old. They haven't been around that long. So a lot of my clients who come back to review their trusts after a few years, if they don't have a provision in there that addresses what to do about ABLE accounts, we'll add that language. The Secure Act that we're going to talk about later, that's really new. And my third-party trusts that I draft now address what to do about the Secure Act, but previous third-party trusts just don't address it. A third-party trust can be a testamentary trust, meaning that it gets created under your will, or it can be an inter vivos trust, which means it exists during your lifetime. If you have grandparents who want to either make gifts to your special needs child, or who might want to leave assets for your special needs child in a will, or name the trust as the beneficiary of something, then it's a good idea to make it an inter vivos trust, because if you have a testamentary trust, that means you really don't have a trust until you're gone. And there is no age limit. You can create and fund a third-party special needs trust for a beneficiary of any age. one of the things to think about is how much you want or need to put into your third-party special needs trust. I can't answer that question. The answer is going to be different for every single beneficiary and for every family, because it's going to depend in part on your family's resources. But a rule of thumb is that if your child has needs that would qualify them for a comp waiver, probably it's going to take $3 to $4 million to take care of them over the course of their lifetime. If you're hyperventilating right now, don't worry, because that takes into account the fact that hopefully your child is going to qualify unless we mess up the means test or the resource or the income test. Hopefully your child's going to qualify for benefits that's going to make up some portion of that $3 or $4 million. A way to get a fairly accurate idea of what you should plan to have for your child is you can either go to a type of financial planner that is a chartered special needs planner. So that's somebody with a special certification. And you can do a life plan where they will assess what benefits your child has, what benefits they're likely to qualify for later, what you have, and how you might best allocate resources as a family. Another thing you can do is there's something called futures planning. It's similar to life planning, but they call it futures planning because the people that offer this planning at the Bobby Dodd Institute are not certified financial planners. So they're not as qualified to do projections about how your investments are going to do. But I've got a whole slide on this. Bobby Dodd offers futures planning where they look at your child and they look at, what does your child want for himself, for his life? What do you want for your child's life? They analyze what type of benefits your child is likely to be qualified for, both with Social Security and Medicaid. They look at potential housing situations. They look at also just building a life for your child. Do you feel that he's going to be potentially able to work part-time or do some volunteer work? And they look at long-term needs. So if you're interested in looking into futures planning, the website here for the Bobby Dodd Institute is here, and there are two people that you should email. Anna Mackey is the Director of Benefits Navigation at Bobby Dodd. She is brilliant. She is a benefits guru. She is a great person to contact, but she can direct you towards the right person to do futures planning through Bobby Dodd. And Sheila Carter is a beneficiary advocate, and her email is also here. And she is wonderful. And so if you're interested in finding out more about that, the Bobby Dodd website is just a great place to poke around for lots of information, but for futures planning, among other things. So funding the third-party trust, I just make the baskets. I can't give you the money to put in there. So once I've made the basket, then you have to figure out what are we going to do to get stuff in here. And of course, many people use estate assets, meaning that your will would direct some or all of your estate into this basket that's called a third-party special needs trust. This trust, as I said before, can be the beneficiary of a life insurance policy. If you're young enough so that you have some flexibility about your life insurance planning, you may want to take a look at the resources you have with a financial planner and determine whether permanent life insurance is a way to come up with some of the money that you need to fund this third-party special needs trust. We are not Clark Howard families in special needs land. I am not a big fan of term life insurance for special needs families because term life insurance ends at some point. And typically when the term policy ends, you're too old to qualify for a good rate or even potentially for any life insurance at all. So the time to get permanent life insurance, if you have a child with special needs, is as young as you can, because it's going to be the most affordable. And that is life insurance that will never go away. And to me, that makes sense unless you have other assets that you feel confident will be enough to take care of your child, because you've got a need that's never going away. This is a little wandering down a little side path a little bit here, but One of the things that you may find it a good idea to do if your child qualifies for SSI is to charge them for room and board so that you get the full SSI amount of $841 a month. If you're giving your child food and shelter by letting him live with you, they will reduce your Social Security, your SSI payment, or your child's SSI payment by 1/3. If you have a room and board agreement with your child, so your child is essentially paying you rent out of their SSI money, a lot of parents feel kind of bad about that because that's supposed to be their child's money. And here they are charging them rent when they would really be happy to just let their child live in his room and eat out of the refrigerator for free. So if you are getting rent payments from your child to keep them maxed out on SSI, once you get paid that money, it's yours. You can do anything you want to with it. But if you want to do something with it that will benefit your child, you might consider sort of reverse engineering the permanent life insurance. So if you're charging, say, $600 a month in room and board, and you're looking for a permanent life insurance policy, you can just go to an insurance agent or to a financial planner that can help you choose an insurance product. And you can say, how much coverage can we get for $600 a month? And essentially the SSI money that you're getting paid in room and board is paying the premiums on a permanent life insurance policy. And the beneficiary of that policy could be the third-party special needs trust. So that's a guaranteed sum of money that you know is headed into your child's third-party trust, in addition to whatever other assets you might put in there. The third-party trust can be the beneficiary of an IRA. And because of the Secure Act, an IRA has become a really tax-efficient thing to put in a third-party special needs trust. We're going to get to that more in a minute. Friends and family can also make gifts either during their lifetimes or under their wills or under their revocable living trusts. They can use the third-party trust as the beneficiary of life insurance, retirement accounts, whatever, anything that has a beneficiary designation, as long as the third-party trust is an inter vivos trust. Because if you have a trust that exists under your will, remember, you don't have a trust while you're alive. So grandma and grandpa can't put anything into it unless you die before they do. If you've got a family member or if you yourself are wealthy enough so that you care about estate tax, most of us in America don't care about estate tax these days because the exemptions are very, very high. But if somebody that you know wants to do tax planning, and if they would like to make gifts so that they can get funds out of their taxable estate, you could choose to make your third-party trust irrevocable so that other people can make completed gifts for gift tax purposes into that third-party trust. We do not have enough time for me to explain that in any depth, but it's a thing that can be done if people want to do it. Let me see. I think this is almost my last slide. So I have a few trust provisions that I always include in my third-party special needs trusts, and I love them so much that I'm going to tell you about them. So my very favorite is I always have a provision that allows the trustee of the third-party trust to own a home, and I give the trustee discretion to charge rent or not charge rent. And the reason that I love this provision so much is because you may remember that I said we can't put first-party money that belongs to your child, into a third-party trust. We cannot do it. But if the trust owns a home and your child lives there and the trustee charges your child rent, then we can essentially launder your child's money into the third-party trust. So it's not really costing your child anything. Let's say you've got a young adult child who is tired of mom and dad's house and wants to go out in the world and be cool and have his own place. The trust could buy, let's say, a nice townhouse, and they could allow the trustee, which could be you, the trustee could allow the child to live in the little townhouse, and they could say, we're going to charge you $700 a month to live in this townhouse. So it's a way to keep the SSI nice and low, because every month we're taking $700 of that $841 right off the top to pay rent. It's a way to get first party money into a third party trust, because we're not gifting it in there. We're doing an arm's length transaction to get it in there. And then another advantage of this plan is someday when you're not here anymore and you have another trustee, maybe it's a corporate trustee that's managing this property and potentially owning this home. The home is a trust asset, and the trustee is required to maintain all trust assets, which means the trustee has to make sure that the roof isn't leaking on that trust asset. If there's a plumbing problem, the trustee has to know about it. They're expected to know about it as a fiduciary, and they're supposed to fix it. But the trustee is also supposed to check every so often and make sure that there is not a random person sleeping in the bathtub. The trustee is supposed to know that there is not a meth lab in the kitchen. So it's a way to kind of impose a little oversight on the house and what happens to the house if the house is owned by a trust. And because this home would be owned by a third-party trust, there's no estate recovery at the child's death. So you would never, ever want to put a home into a first-party special needs trust, even though you could. It would be a terrible idea, because a house is not liquid. You can't spend a house. So if a first-party trust owns a home and your child lives there until they die, Medicaid is going to take that house at the end of your child's life. So bad plan, but it's a great plan to put a house in a third-party special needs trust. Another provision that I love to include in third-party special needs trusts is I always give the trustee the discretion, if they wish, to fund an ABLE account. And ABLE accounts, we're going to talk about that in more detail in a minute, but an ABLE account is basically sort of a parking space. It's an exempt account that your child can put money into, and then it stops becoming a non-exempt resource and it becomes an exempt resource. So it's a good way to get rid of relatively small amounts of money that would otherwise disqualify your child from getting SSI and Medicaid. The ABLE account has a Medicaid payback, so we don't want to go out of our way to put money in there. But the one really great reason that I can think of to fund an ABLE account is the in-kind support and maintenance rule. So as I mentioned before, if any source other than SSI or an ABLE account is paying for food and shelter, then Social Security is going to say, this person is getting in-kind support and maintenance, and we're going to reduce their SSI by a third. So what if your child doesn't live with you and you don't have the power to set their cost of food and shelter at some amount that's below the $841 a month, that is the maximum that they could be getting in SSI? What if they live at Just People? What if they live in Annandale Village? What if they live in Special Needs Cobb in a group home and we have to pay rent? We don't have control over how much that rent is, so it's probably going to be more than $841 a month. If you're paying that extra out of pocket, SSI is going to reduce the SSI amount by a third because they're getting in-kind support and maintenance. But if instead we're putting money into an ABLE account and the ABLE account is paying for the excess food and shelter costs, then that is not considered in-kind support and maintenance, and there is no 1/3 reduction. So when we get down the road someday to where the child's funds are, the support is coming out of a third-party special needs trust, it's nice to have the option for our trustee to sort of, again, launder the third-party trust money into an ABLE account and back out again to pay for food and shelter costs if we need to. But again, ABLE accounts are subject to Medicaid payback, so we don't want to go out of our way to cram a whole bunch of money into an ABLE account just for no particular reason. And then finally, the SECURE Act it passed at the end of 2019. It was in effect at the beginning of 2020. And the Secure Act dramatically changed what happens to inherited IRA proceeds. So under this new rule, unless you meet one of 5 exceptions, if you inherit an IRA, you have 10 years to take all that money out and to pay income tax on it. But one of the exceptions to that rule under the Secure Act is if you are a disabled person or a trust for a disabled person, then you can stretch that IRA out over your actuarial life expectancy instead of taking all the money out and paying income tax on it all in 10 years. So that is tremendously advantageous for income tax purposes, especially because if your child is the beneficiary of an inherited IRA, if your child's trust is the beneficiary, we don't want to name the child, we want to name the trust. But if your child's trust is the beneficiary of an inherited traditional IRA that's going to be subject to income tax, not only can we stretch that IRA out over your child's actuarial life expectancy, we can pay income tax at your child's income tax rate, which is likely to be little or nothing because they're not likely to have a whole ton of taxable income. So the IRS just kind of inadvertently gave us a nice little tax planning tool here. And I would love to talk about this at greater length because I know it's confusing, but I am afraid I've kept everybody on this talk for such a very long time that I'm just going to have to move on. Quickly, special needs trusts versus ABLE accounts. They're not the same thing. In a special needs trust, every single dollar that you put in is exempt. If you have $10 million in a special needs trust, all of it is an exempt resource. Your child can still get SSI. The assets that you put into an ABLE account are exempt up to $100,000. So the first dollar over $100,000 starts to reduce your child's SSI eligibility. So it's another SSI offset dollar for dollar. So you can have any number of special needs trusts if you're willing to pay for them. You can have as many as you want. You can have as many different types as you want. You are allowed to have one ABLE account per owner, and that is it. Special needs trusts can receive any amount of contribution. It can be a gift of any size. The maximum contribution that you can put into an ABLE account is $16,000 a year, with one exception, which is if your child has a job. If they don't have a 401k plan through their job, then they can put in $16,000 a year plus the amount that's equal to the federal poverty level of their earnings. So this year, that's $12,880. That number changes every year. So in other words, if your child earned, let's say, $4,000 last year, they could have put $16,000 from any source into their ABLE account, and then they could have put in an additional $4,000 of their earnings. A third-party trust, as we've talked about, has no estate recovery. A first-party trust does have estate recovery, and an ABLE account is always subject to estate recovery by Medicaid. So that is it for me, unless there are questions, and I'm happy to stay as long as anybody has questions.
Thank you, Kim. We're going to go ahead and open up for questions. We have a pretty decent sized group. So I'm going to keep everyone on mute. And you have 2 options to pose a question to Kim. One, you can click the reactions button, which is down, excuse me, on your Zoom toolbar at the bottom of your screen next to live transcript. And you can just click the raise your hand sticker and I'll unmute you and you can ask your question to Kim. You can also type a question in the chat and I'll relay the question to Kim to answer. And in case we run out of time, We'll have her contact information listed at the end, and actually she has it right here for you. So if anybody has a question, let me know. Okay, we have one. So Kay said, thank you. That was fantastic. Latoya said, thank you, Kim. You are awesome.
Thank
Randy,
you.
Randy said, how do we apply for room and board agreement to receive the full $841?
Well, you don't apply for a room and board agreement. A room and board agreement is basically just a little contract. If you email me, I can send you one. It's like a 3-page long contract that basically just says, we are going to charge you whatever this amount per month to live in your room and eat out of the refrigerator. And that's going to be all of your food and shelter costs for the month. And the reason that that's a useful thing to have is that if your child is on SSI, if they're not getting $841 a month, if you have a child that's on SSI right now, do the math and see if it's reduced by a third. And if it is, it's because you're not charging your child rent. So the way to fix that is to go back to Social Security with your signed room and board agreement and say, look, we're not giving our child food and shelter. We're charging for it. Here's our agreement. And one little quick note about that, if your child is under guardianship, they don't have the capacity to sign a binding contract, but their guardian can sign a binding contract. So if you're your child's guardian, then you can sign a room and board agreement on behalf of your child.
Okay, Randy said that they do have guardianship.
So you would want the guardian to sign the room and board agreement because your child can't be bound by a contract because he's incapacitated.
Okay, Randy said thank you. Okay, we have a lot of thank yous.
You're welcome.
And Tina said, Kim, what do you do if you plan on letting your child remain living in the house when the parent passes? We already have the comp waiver.
Ooh, the comp waiver is excellent, and congratulations on having the comp waiver.
Definitely.
What you could either make a specific bequest in your will of the house to the third party special needs trust, if assuming that you have one, or this is so fact specific that it's really, I can only give you a kind of a general answer. In some cases, people envision their child living in their house long after they're gone. And you may want to think about how long that's going to be feasible. Because if you own a house where, you raised all your kids and you've got lots of bedrooms and lots of yard that has to be taken care of, and, maybe the house is getting older because it's been your family home for a long time, at some point, it may not be the best idea for your child to live in that house. So you could say nothing about the disposition of the house and just let it fall into what's called the residue of your estate. And maybe it's an appropriate thing for your child to live there. And maybe it's better to sell that house and take that money and buy a smaller house or a townhouse with no yard to mow, or a house that's in a location that's easier for your child to get to public transportation on. It's really hard for me to say anything specific because I don't have enough information. But if you specifically want your child to stay in the house, then you could make a specific gift of the house to a special needs trust. And then we'd have all those nice advantages that I mentioned, that, the trustee would have the job of making sure that the roof doesn't leak. There's not a wiring problem. Houses need all kinds of random things and we don't know what they're going to be, but we know that they're going to need something at some point. So it's nice to have somebody whose job is to make sure that that house gets taken care of. And if it's a trust asset, then the trustee's job is to make sure that the house is in good shape.
Okay, Lucy has a question. Lucy, I'm gonna unmute you.
Hi, yes, I have a question. My son, he already turned 18. So he has SSI, but it's still continued. What do we have to do next? Like, what's the next because they're still sending him his, like his regular check.
I'm not quite sure what you're asking. He has SSI
Mm-hmm.
and
And it was supposed to either roll over or they were supposed to ask me for what you mentioned, like to charge him for the room and board and all of that. But I never got any of that, any paperwork or anything. So do I have to reapply for Social Security for him, or how does that go? Does it roll over?
are you talking about having to reapply for Social Security because he's now 18? Was he getting SSI before he was 18?
Yes, ma'am.
Okay. So they may just roll him over, but now that he's 18,
Mm-hmm.
he's a household. Now that he's 18, you absolutely should have a room and board agreement with him.
Okay.
It's possible that they just haven't realized that he's rolled over. But if he's not paying you rent, then if they figure out that you aren't charging rent, they may reduce his SSI by a third.
Okay.
So
So
I'd go ahead and do a room and board agreement.
okay, how can I do that? Like, where do I go? How do I?
You can Google room and board agreement.
Okay.
It's a fairly generic little contract.
Okay.
It just says that and make sure that the amount that you charge is
Mhm.
less than $841 a month.
Okay.
Because the purpose in having the room and board agreement is so that you can show Social Security that
Mhm.
all of your child's food and shelter costs are getting met by SSI.
Okay. So you mentioned $600 a month for room.
I was making up a number, but that's a perfectly good number.
Okay.
So,
and then also can I add food for that and like transportation, or it should just not go over?
Your child is paying for room and board out
Okay.
of their SSI, and you don't need to itemize. You don't need to say like, here's our grocery receipt and he ate these things that are circled here.
Okay.
You have an agreement with your child, and the agreement is you pay me this and I'm going to let you live in your room and I'm going to let you eat here.
Okay. Got it. Thank you so much, Kim. I
You're
appreciate
welcome.
it. We've got a lot of information. We appreciate all your help.
Oh,
Thanks.
good. Well, I'm glad you found it useful.
Thanks. Bye-bye.
All right, so Cassandra, we're gonna get to you in just a second. Emily asked, can the parent that pays child support ask the judge for a reduction in his monthly payments if the child starts receiving SSI benefits?
Like an offset. I think that would depend on the judge, and it would depend on the initial settlement agreement. I'd have to see the settlement agreement before I could really answer that question.
Okay. Do you have a follow-up, Emily? Okay, we're gonna go ahead and go to Cassandra.
Hi. I typed in the chat, but my daughter's 15. She's going to be 16 and wants to get a summer job at Publix. So I was wondering, she doesn't qualify for anything right now, and I don't know why. I'm a single parent. I'm on a teacher's income. Like other people, when I lived in Massachusetts, she got everything. In Georgia, she qualifies for nothing. So she wants to get a summer job. So I'm wondering if she gets a summer job, because everything will be in her name, is that money that she starts to earn at 15, 16 going to affect her in any way in the future?
It will only affect her in the future if she still has it when she turns 18.
Okay.
But I mean, I'm assuming it's going to be a relatively small amount of money. What you could do if you wanted to make her money exempt for benefits purposes for the time a few years from now, when you're potentially applying for SSI for her, you could open an ABLE account. And she could, I mean, right now, it doesn't matter what she has, because Social Security is attributing any resources that you have to her because she's a minor. But when she turns 18, she needs to have less than $2,000 in non-exempt resources in her name. So if she wants to earn money and save it, she can do that. For now, she can do it any way she wants to because she doesn't qualify for anything. But if she wants to earn money and save it later, beyond the age of 18, the easiest and least expensive thing to do would be to just open an ABLE account and let her park the money in there.
Is an ABLE account different than a basic bank account? Because I have a bank
Yep.
account in her name. So
The
I should,
bank account is a non-exempt resource, but the ABLE account is an exempt resource.
okay, so where would I do that? I missed that.
Oh, you can go online and open an ABLE account. Oh, I should have included that slide. I did not include that in my slides. If you Google Georgia stable account, it'll take you to the website. So, and it's the federal legislation that created ABLE accounts just said, okay, states, you have permission to create these things. And then some states went ahead and created them. Other states said, we don't want to do this. It's not going to be cost efficient. Georgia is, of course, one of the states that said, we're not doing this. So Georgia and a number of other states decided to piggyback on the Ohio ABLE account. And the Ohio account is called a stable account, which is why you would Google Georgia stable account and it'll take you to the website. It's really easy to open an ABLE account, but you can only have one.
Okay,
So, but you can open it online. It should take just a few minutes.
okay, all right, perfect, thank you.
You're welcome.
I'm gonna reach out to you privately.
Great.
All right, I'm gonna unmute Emily real quick. I think she has a question.
Hi, thank you. Sorry,
Okay.
the system was not allowing me to unmute. It
Oh,
kept
no.
giving me the message that the host was not allowing it. So sorry. Now she did it herself. So my question was, if the parent that is paying for the monthly child support, can they ask the judge to either reduce their amount or not pay it at all because the child starts receiving SSI? And you said it depends on the settlement agreement, which
Mhm.
means to me that the settlement agreement has to encompass far more than just child support. So I'm in a quandary as to, if I see a special needs lawyer, they're going to want a settlement agreement. It's like, what came first, the chicken or the egg? I'm going to need to know what to put first in the settlement agreement before I can go ahead and see a special needs trust lawyer. But if I don't know what I don't know, I'm going to, mess up and not put it in the settlement agreement.
Well, you shouldn't be putting anything in the settlement agreement. So, I mean, you should be seeing a family lawyer that knows about this provision, or they should be working with a special needs lawyer I mean, that's one of the things that I do is I work in consultation with divorce lawyers and review settlement agreements to make sure that they're worded properly. So if you don't address this issue at all in a settlement agreement, if your agreement just provides that child support will be paid until age 20, or it could even provide child support will be paid beyond age 20 if the parties agree to it. Age 20 is the limit of what a judge can order for child support. But if the parties agree to pay child support beyond age 20, that's enforceable if it's agreed to. But if the settlement agreement says child support will be paid beyond the age of 18, if it's just flat out paid to the other parent, it is going to offset SSI dollar for dollar. We'll disregard $20, and then every additional dollar of child support that gets paid for that child is going to offset SSI. So if it's enough child support, it would wipe out SSI, which means we've got child support essentially taking the place of SSI. So it's just not a good use of the family resources, because it's possible to have child support payments getting made and qualify the child for SSI. So that's more money that's available to take care of the child.
Okay. I like your idea of putting the child's SSI money into the special needs trust so that it pays a life insurance policy.
Well,
I
you wouldn't be making SSI deposits into the special needs
Yeah,
trust,
into the
but
trust.
you'd be like, if you're charging your child for room and
Yes,
board,
yes,
then
yes,
it's your money. Then it's
yes,
not SSI money anymore. Now it's yours.
yes,
Once it's yours, you can do whatever you want to with it.
yes, yes, I understand that. Thank you.
You're welcome.
All right, thanks, Emily. Tina asks, Kim, what if the child is 28 and already receives SNAP? Then can we not count that under SSI as room and board? So the child has more to go towards a room rent and utilities?
I'm not sure I understand that question. Are you saying, it sounds like what you're asking is, does SNAP reduce SSI because it's paying for food? If that's what you're asking, then the answer is no, it does not.
Yes.
Is that your question?
Yes.
Okay. Yeah, so you can be on SNAP benefits and still get $841 a month in SSI.
Does that answer your question? Okay, cool. Okay, thanks. Okay, great. And then we have another one. Jeff says, if a child is receiving benefits based on a parent's retirement, is it still important to charge them room and board with an agreement in order to have them receive maximum benefits?
The in-kind support and maintenance rule only applies to SSI. It does not apply to SSDI. So if your child is on SSDI, even if you're not charging rent, they'll still get whatever it is that they're entitled to get under SSDI. There might be other good reasons to charge rent though. Like, we always care about the means test. Even if your child is on SSDI and Medicare, we still want to keep your child qualified for the now comp waivers. So we always want to make sure that your child has less than $2,000 in non-exempt resources. So there are various ways that you could do that. You could just, take the SSDI money every month and spend it on things that your child needs. You could put it into an ABLE account. You could put it into a first-party special needs trust, but I don't see any downside, and I see a lot of upside to your continuing to charge your child rent, even though we don't care about the in-kind support and maintenance rule anymore, purely to launder that money into your hands. So if your child can't give you their SSDI money. They're not allowed to do that, but they can pay rent. So if your child is paying you rent, then you're taking the money out of your child's hands where it's first party money, and you're putting it into your own hands where it's third party money. And in the process of doing that, you're also helping to keep your child's bank balance below $2,000. So we don't care about the ISM rules anymore if your child is on SSDI, but we still may want to charge rent for other reasons.
Okay. Emily asks, okay, Jeff said, makes sense, thank you.
You're welcome.
And then Emily asked, does the SSI monthly amount vary from state to state?
No, I believe that's a federal amount.
Okay.
And it's $841 a month.
Cool. All right, does anybody have any other questions? If you have any other questions that we didn't answer here, you can go ahead and email Kim. Her email is right there on the screen. You guys had some awesome questions. We're gonna go ahead and wrap it up. So that is all for tonight. Thank you guys so much for participating and coming. If you have any additional questions, you can reach us by email or telephone. We're happy to provide you with this additional support. I hope you guys have a good Friday and a good weekend and a good night.